May I please your lordship? I beg to mention item number 21 of today's list, lordship. We have served an advance adjournment slip yesterday. ठीक है.
21.
21, lordship.
I am the respondent, Lordship. I have taken the consent, Lordship. Lordship, my prayer is only to fix a date, Lordship.
15 September,
Lordship.
if it is convenient for your lordship.
Same date.
15?
Same date. Same date.
Okay.
Both sides are represented
Yes, Tuesday.
on the prayer made by Ms.
A.
A.
Chakraborty.
Chakravarti, learned counsel for the appellant. The matter is adjourned today. Next matter is agreed to by both sides based on
15 September,
15
lordship,
September.
Tuesday.
Okay.
Obliged.
Most obliged.
Wait, please, my lord. My lord, in item number 2, my lord, the opposite side has filed a rejoinder affidavit yesterday, prayer for acquisition of this land. I'm so obliged.
May it please your lordship. Lordship, I'd like to mention one item for listing lordship. That is, number being IA Civil 2987 of 26. It was actually, the numbering was done yesterday. Lordship, this IA is for actually substituting the legal heir of respondent number 19 in item number 3. Lordship, Lordship, it may be called for today and the tag.
It won't come like that. It has to be registered and then it has to be listed.
Lordship,
Give it to the courtmaster and see. We can't assure anything.
it's been registered.
Give it to the courtmaster.
Lordship, actually, I am one of the legal heirs to be substituted. I have appointed my friend to represent.
No, that's okay, but the process is that IAs have to be listed. It can't be just called for and taken up. The orders will not be uploaded. Unless the matter is in the list, it can't be uploaded. No orders will be uploaded. It has to come, follow the process and come. So therefore, we don't know. We allow your prayer, but we don't know what will happen. Give it to the courtmaster.
Lordship, when I'm back in 30 July only we have filed, but my clerk.
You see, I can tell you, I cannot make you understand.
Lordship.
That is for your wisdom to understand what I'm trying to say. I can just tell you. I cannot do anything more.
Lordship.
Understanding is your wisdom.
Thank you.
That is here. Okay, back to mention item number 23, my lord.
Hmm?
23, my lord. Concept with the other side, my lord. Yes, I am seeking item number 23, my lord.
It's a 2019 matter.
Yes, my lord. My say is not well, my lord. Let's finish the next one.
You have to wait till we call it. We'll take up the matter. 2019 criminal appeals, it's very difficult to adjourn.
This is my series not well, my lord. My series is not well prepared.
No, but then it would be conditional. We'll fix it next week.
Next week.
And we'll say that the bail would be subject to further orders because you are on bail. Why should you, you understand, but why should you be on bail if you are wanting an adjournment in a criminal appeal? Can you give an undertaking that you will do it next week? You see, you're not ready to give an undertaking. If you are adjourning a matter, you to take it up next week. You are not willing to give an undertaking that you will do it.
You should wait till next one. Fix it.
So the state who's there, APP. There's also a private respondent. You'll have to wait. The others are not there. There's a private respondent also. Have you taken consent?
Yeah, well, inform the inform.
You have informed.
Over
Okay.
the
Your name?
A. Hussain, my lord.
A.
Hussain.
Mr. A. Hussain appears on behalf of the learned counsel for the appellant on record and submits that with consent of the learned counsel for the private respondent, the matter private respondent number 2, is praying for an adjournment. Next paragraph, this appeal being of the year 2019, the matter is reluctantly adjourned. First, however, next paragraph, however, the learned counsel praying for adjournment undertakes that on the next date of listing, no prayer for adjournment should be made on behalf of the appellant. So stop. It is made clear that if on the next date of listing, the prayer for adjournment is made on behalf of the appellant, the bail granted to the appellants. Please give me a record, item 23. The order of bail granted to the appellants would be reconsidered. Next paragraph. List on due date next week. Mhm. 7th September. No, Monday, not Monday. This will be your hearing. Yes.
Well, it's yesterday my senior mentioned the habeas corpus petition challenging the order of detention passed in the National Security Act. It was allowed, it was supposed to be listed today. But what happened was, meanwhile, the registry registered the case number as WPC. Later on, it was re-registered as WP criminal, and we were advised to mention it again today morning. So it may become today. Grateful. Please, your lordship. I beg to mention item number 22. Also, I have taken the consent of the other side, which is asking you to grant us adjournment for the lordship.
You are for the appellant.
Yes, lordship.
Lordship, I appear for the caveat.
Lordship, and also I pay to you to extend the interim lordship.
Until further order.
That is difficult.
Lordship, it is until further order, Lordship.
If you are extending the interim order, we take it up next week.
Lordship.
If you are extending the interim order, then we will take it up next week. Both sides are represented. The prayer made by and transferred for the appellant, the matter stands adjourned today. Interim order passed, the stands extended till the next date of listing. This is the matter for hearing on 10 September 2026.
There is Lordship, if that contempt is there, Lordship. No more contempt case is there, Lordship. This matter cannot come up before the Chief Justice, your Lordship. That is why maybe for a little bit later, case, your Lordship. 14, 15, Lordship.
Okay, 15 September.
Obliged, lordship.
Daily list item 1 for admission.
May it please your lordship. Lordship, arguing counsel is lacks in court number 2, so this matter may be taken up at 2, lordship. Deeply obliged.
Item number 3 for orders.
Service of states upon few respondents are not complete, your lordship. On last occasion, I paid for substituted service, your lordship. But your lordship directed that the case records from the honorable single judges in dispose of petition may be got. And the records are here. The addresses your lordship wanted to verify. The correct one. The correct one.
Seventeen out of this respondent,
Lordship.
17 is a state
field number
respondent,
17 has been substituted.
Yes, yes, yes.
and it's a
Now-
state respondent.
Insofar as 18 is concerned,
Okay.
18, the address is very vague.
Vague.
Kamakhya Gaon, Moja, Jalukbari.
Very vague.
This is, you can't ascertain. You'll have to bring the correct address then serve. I am a bit apprehensive of service or made an address which is incomplete,
Yes.
because we don't know whom you are serving.
Lordship.
Lalit Mohan Das is a very common name. Maybe there are more than one.
Lordship, they don't have any house number there, so
That's
From-
okay, but there must be something to know that address.
I'll ask them to seek the landmark or something like that.
Something
Because
has to be
from-
brought in.
18.
The name of the father is not there. So far as 18, 44.
Right,
44
after
is
18,
so vague.
after 18, whether 26 is there, but 26 has got a
26 address is complete.
completed, that's what I'm.
Yes. Now
Yeah.
from
44.
44. Okay, 44 is there, 44, 52, 57, 63. They have a house name. At
No,
the-
44 housing is not there, I think.
Yes, it is there in the last page of the first title, page
From-
11.
Yes. From 44 to 67.
44.
44 to 67. Okay.
Oh,
Okay.
okay.
From 44 to 67. Only
No, sorry, 44 is not there, only Maligaon, Gauhati.
Yes,
44 address is incomplete.
52 address is there, the common address.
45 to
44 like this.
67 is complete address.
The postal remark on 44 is that the address is left, your lordship.
No, you see, if I am the postman, that is the report I will also give.
Lordship, the writ was filed in 2003.
So that's okay, but
This
you
report,
must understand the problem of the person. Maligaon, find out a man is finding a needle in a haystack, what is called a haystack.
I may be wrong, but I don't think most of these respondents even contested the writ petition. They were not represented.
That's not the issue. Either you struck them out or you serve the notice. You see, my understanding of the issue is that unless I arrive at a satisfaction that you are avoiding service, I'm not permitted to take recourse to substituted service. The first fundamental is I must arrive that Mr. Fukan is avoiding service. How do I record that?
The only problem here, lordship, is that this respondent number 44, they filed the impeachment petition on the basis of that they were included in the original writ petition, your lordship. So these are not known person to the petitioner. So
No, that's okay.
regarding respondent number 18, I can understand
But-
since he is a
No, but
question
show
of
that
my caste.
which I was that before implemented.
before the
Interim order was.
Three one eight. We'll drag it out. Maybe 1318. 1318. What would you say about that? If yes, disclose the vague address, then we'll accept your contact. That I is not there, but we suppose that you are right.
Lordship,
Because the office endorsement is there, implemented respondent 44 by order dated 25/15, passed in IA 1318.
yes, your lordship.
This is the address given. Okay, except for 44.
Yes, your lordship.
52, 57, 53, okay. Only 18 you have to ascertain the correct address.
Lordship.
And in the meantime, we are issuing direction that you can serve the same mode by two others.
Yes, ma'am.
Heard Mr. P.K. Sharma and counsel for the appellants. Also heard Mr. D. Mazumdar and senior counsel. You are appearing an additional advocate general? As additional advocate, additional advocate general for the state. And Mr. A. Pupal, learned counsel for respondent numbers.
65, 66 and 67.
5,
65, 66, 67.
5, 66 and 67. You have what, Ms. Karita? Okay, along with. It's okay, we record your name together with me. Just a moment, Ms. Karita, your first name I forgot.
And Bode.
Then Bode, I'm sorry, I'm extremely sorry. And Bode, standing also for the revenue department. And Miss. Yasmin on behalf of Mr. R.C. Sekar, senior counsel for respondent numbers. 41, respondent number 41. Next. The pursuant to order dated 37/2026, the record of the record of WBC 6498 of 2003 is received. So, sir, it appears that respondent number 44 was included by order dated 25/2016, last in IA 1318 of the 15. So therefore, the address of respondent number 44 as provided in the first title is the same address which has been disclosed by the said respondent number 44. As far as the address of respondent number 18 is concerned, the address is village Kamakhya Gaon, Muza Jalupari. According to the court lines of the this first. They are also implemented by auto casting. Six 1 4. Is there a ticket? Just check who is the petitioner in Miskes 614 2009 and Miskes 1484 of 2010 for the applicants. However, as per record, the respondent number 18 was implemented by order dated 16/9/2013 or passed in Miskes number 614 of 2009 and Miskes number 1484 of 2010. Therefore, the address of respondent number 18 is also same as disclosed by the respondent number 18. The prayer made by the counsel for the appellant is allowed, permitting notice to be served on respondent numbers 18, 26, 44, 52, 57, and 63 by Dusty Mode. And first of steps is required to be taken within 2 working days of the notices Made returnable bond. You can do it in 2 weeks.
Okay.
You can after 2 weeks. Returnable bonds for this one. Period. Then upon service, an affidavit of service shall be filed by the initiative of listing. So wasn't there? But you have to take instructions in the meantime.
Mm.
Huh? It took, his the petition was by the respondent 18 himself. He has discussed this.
He has given this.
Ah. But you have taken the wrong mode in this, mode for service in this writ appeal. Writ appeal was of 2023. You could have served notice to the counsel who was appearing in the writ petition. That is permitted under the High Court rules and also permitted under the order 3 Rule 4. It could have been served. The lawyer will have a mandate in the appeal also. He could have served and work would have been easier. Now from 23 to 26, 3 years is being taken for service.
See, initially, there were some counsels were representing some of the respondents who were impleaded from time to time, because originally the memo of parties was not this big. There were very few respondents, but when the interim order was granted, saying mutation, then a lot of respondents kept impleading themselves
We
from time to
understand,
time.
that's not the point. The
counsels
point
were-
is that once a party is there in the writ petition, the lawyer is bound to take notice to accept notice.
I got on completely, but what happened here was, since ultimately the matter was heard in 22, almost 20 years after the writ petition was filed, a lot of counsels, for whatever reasons, they were not representing their clients and they were not.
That is for that lawyer to take a stand. So far as the court is concerned, we go by the law.
I bowed on.
So it makes, if things make my work easier,
No,
why
then-
will I complicate things?
This lordship would not have to go through all this at this
Yes.
stage of appeal.
And it takes a lot of time, and in the meantime, everybody of who's in the both sides are affected by the
Delay.
stay in the
Delay.
litigation.
Yes.
The deity is also having difficulty in managing the affairs of the land. Then,
And watching all,
huh?
and watching all.
Mr. Mazumdar, you have to take instructions from the revenue department with Ms. Bardoloi.
Yes.
You see, the fact is that it is the prerogative of the government to do the settlement process.
Right.
So what is preventing the government from doing it?
Settlement.
Yes.
But
The
there is- there is-
settlement in the
there is
settlement
some-
process,
But there is some interim order here.
no, you see, everything can be tentative. So you are doing an exercise, finding out the
If you
status.
makes an observation, then, but they have,
And-
since there is some order, interim order here.
That's okay. It will not be incorporated without the order of the court, but the exercise can be done. At least the status of people who are there. Mr. Fukan had last time said that the encroachments are coming up close to his construction.
Yes.
Those things are there. Those things can be easily found out.
Interim order will be here.
On the 17th February 2023, there is an order of status quo. As it exists,
No, it's okay. You maintain that status quo, but the exercise can still be done.
unless
something is saying, because officers will be saying that there is no as it exists today
Okay.
in
You
respect
see,
of the
you are not
land.
disturbing the status quo, meaning what? Status quo does not mean that you will not, make the,
And the status quo, if you lot to read the order, status in revenue record of. It says status quo as it exists today in respect of the
17
land
to
in
23.
question, including possession and status and revenue records shall be maintained.
yes. So
So
you're not
revenue
disturbing
records
that.
cannot be changed.
No, you're not changing it,
My lord,
but you're doing the exercise. You see, what do you do when you do a settlement?
my lord.
You make a draft noting
Some
in
observation
the
from,
chitta.
some observation from your lordship.
And then what happens is that after that, this is recorded in the final draft,
Ma'am.
and then it goes to the draft Jamabandi, and then only the main Jamabandi is touched.
Okay. Some sort of observation from your lordship.
We'll put a notice so that everybody will address us on that day, and the next date we'll
Madam.
pass the order.
I have booked an I specifically for this because the direction of the learned single.
Which is your I?
So this is I number 690 of 2025.
It not be in terms of this prayer, but
The second thing I would like to draw your lordship's attention to, we say that the implementation of direction 2 of para 12 of the learned single judge's order dated 27th October 22 in the writ petition. If I may,
Lordship
quote
may,
that order.
possibly lordship can, may observe that on the next date, this application will be taken up. So the,
no, we put the specific.
This direction 2 was clearly in the interest of the appellant, your lordships. Therefore, in the retainable area, the encroachments that are happening within the retainable area, that should be at least removed. So that will not be to the detriment of the appellant, is my respective submission.
It will. The reason is that we have already said, you told so many times, the retainable area was never determined. So whatever is altered will be the land which would fall into the retainable area. Invariably, it will fall.
If I may only
No
show-
amount of argument can make us take a different view.
If I may only show this paragraph, page 293, if your lordship will only take it up. This is their own argument, Roman 11, page 293.
Because you see this direction number 2 is the one which will be highly, what do you call, it will be highly contested. The reason is,
there is a
if it is found that the retainable area earmarked, that was never done.
because everything has to take place in an area which is under encroachment, considering the retainable area. So unless the main issue is decided, possibly this.
Very difficult, Lord. I have to think with following perspective, if you lordship may just allow me to read this para 11 at page 293. This was their own prayer, the appellant's own prayer in the writ petition. Roman
No,
11,
that-
page
You see, that prayer will be determined only when we finally hear the matter.
correct.
By an interim order, we can't allow the main prayer.
No, it's only on the question of, Milord, in the interregnum, Milord, whether some permission may be granted.
Possibly my answer is not correct.
We are not
The-
saying that your proposition is incorrect. But what the problem is that we don't want to steer the hornet's nest
Yeah.
unless we have a protective gear.
I
It does.
completely bowed on.
The reason is very simple. The retainable area under the 59 Act was never determined. Now in 2026, we are wanting to determine the retainable area which existed in 1959. That is an exercise which in my mental calculation cannot be done.
Cannot be done.
And that was the reason for which the petition was dismissed. Court said that
Delay in
a
access and
retainable area will be determined on the basis of the, my lord, configuration prevailing at that time. That is not longer available,
You see, the cases of this nature,
my lord.
is a matter where nobody wants to take a lead. For example, if we ask the developer to sit down and have a discussion with the government and the other respondents to find out whether by taking or leaving some areas, the retainable area, they are ready to determine it now.
Yes.
So that exercise nobody will do. Number two, there's an impediment in that because if Mr. Kukul is in occupation of a particular land, he would not say that I will break my house and I'll leave the land.
Yes.
And my predecessor was in possession for 30 years, my lord. Its government records say that.
We have
That has
59.
the sanctity is never there because you see, your position cannot override the mandate of the act.
Okay.
So, insofar as the issue is concerned, we both are aware of what, if today we are asked to dispose of the matter, we know what to do. But that would not serve anybody's interest.
Yeah.
And it would not lead to a quietus to this matter. If the number one government will do the settlement area, at least for the now, it can be determined. It will be tentative, it will not affect the interim order. If that can be done, we go one step ahead.
Yes, absolutely.
Possibly by the next date, the service part will be over, then your lordship may enter into the merit of the case.
You are referring to page 277. 293.
293 Roman 11. That is on the basis of a, my lord, stand taken by the deputy commissioner in his affidavit.
While holding as aforesaid, that paragraph, my lord, this is after rejecting their main prayers, while holding as aforesaid, this court cannot be oblivious of the fact that the submissions and alternative arguments advanced by Mr. M.K. Chaudhary, learned senior counsel for the writ petitioner, that it is a bounded duty of the state to protect the land of the deity as has been retained.
As has been retained, how does this?
So there was according to an affidavit,
You see, with all respect, unless we have the fact with us that the retainable area as determined,
that has been determined. That's what is recorded in the subsequent lines.
not there. It is not there.
It is not, in fact, my lord, we say deputy commissioner filed an affidavit. This is what has been, just see up 3 lines thereafter, in the middle. In view of the aforesaid, and considering the statement of the deputy commissioner that it can still identify the retainable area, this court is inclined to direct the deputy commissioner, Kamrup Metro, to verify the retainable area already determined belonging to the deity of Sri Sri Ma Kamakhya under the Act of 1959, and that if it is found that the retainable areas earmarked are under encroachment, the deputy commissioner shall evict those encroachers from the retainable area by following the provisions of the Act.
There also, you see, there is a qualified observation to verify the retainable area already determined.
That already determined should not happen there.
It's not there.
No,
This I have not seen.
this is self-contradictory.
This is something on records we have not seen.
This is there at page 226, in the affidavit. Of course, your lordship, you can point out if your lordship is here.
You see, have you never seen a government official making a mistake? If the government official do not make the mistake, there is no work for a high court. You can retire us immediately. On public demand, we will get ourselves retired.
In the process, lawyers also will retire.
For the time being, we are thinking of ourselves.
Lawyers will
So-
make sure that your lordship
No,
don't.
we don't know, but I'm just in a lighter note saying that it is the government officials who make mistakes and therefore the court and the system thrives on that.
Right.
So the affidavit cannot be held to be sacrosanct
No.
that the retainable area of the developed land has been determined. You see, how do you determine, we'll ask you a simple question. How is an area of land determined? Number one, there has to be a survey. Number two, there will be a, what you call the land demarcation process. And if land demarcation process or identification of boundaries has been done, that will all be recorded in the draft chita first. From the draft chita, it comes to the final chita. It is from the final chita that the draft Jamabandi is prepared. After draft Jamabandi, it will be the final Jamabandi. So we'll have 4 records. One may go missing, but there will be a record and trail for other 3. So it can be reconstituted still. It will happen only if all the 4 records are together lost. And in this case, there is a statement on record that the land records have been lost.
Only the Jamabandi.
Then Jamabandi has been lost. And the story is that the Jamabandi was produced before this court.
Yes.
And while the matter was ended, the Jamabandi copy did not reach the authorities.
Exactly.
It is lost in the transit process.
Not would like to give a date, a specific date.
Huh?
Specific date after.
Next. It is. Next, who takes note of the submissions made by Mr. A. Counsel for the applicant in IA Civil 690 of the 2025. It is submitted that. As per the interim order passed by this court in on 17/2/2023, so the following direction has been passed. Inverted comma, next subparagraph. In the meantime, comma, status quo in italics. As it exists today, in respect of the land in question, comma, including possession and status in revenue records, comma, shall be maintained. Instead of not more closed. Stop. Accordingly, it is submitted that this order would not come in the way of the authorities in the Land Revenue Department. Revenue of the Land Revenue Department to proceed with the exercise of settlement in respect of the personal devoted land. The devoted land. As well as the land. Which is covered by village Durga Sarovar and what is the second one? Durga Sarovar and in Kamakya village. Natural.
I think only
The Nilasal Hills comprises of Bhuvaneshwari, Kamakya, Brahmas, and Durga Sarovar. These 4.
4 revenue villages. Okay. 4 revenue villages, namely, please say it again.
Got it.
Please say again, write it down.
Nilasal Hills, which is Bhuvaneshwari, Kamakya, and Brahmas. These 3 are Nilasal Hills, and then Durga Sarovar.
No, whether these are revenue village.
No, revenue village is Kamakya.
So Kamakya and Durga Sarovar too.
Yes, yes. Yes, yes,
The other side of the road.
yes, yes, Yoga server. Brahmabandi, at that point of time, your lordships, is of Kamaikha village and Nilachal hills.
Next one. In view of the submissions given by the non-council for the applicant in IS 7690 of 2025, our report is intended to issue notice to all concerned on all hearing parties to make the respective submission as to why the revenue authorities cannot be allowed to undertake the exercise of land settlement in a manner that it would not disturb the position and status in the revenue records. And the said exercise shall be subject to further orders that may be passed by this court. Next part, please. The this order is being passed, taking note of the fact that the case of the applicant is that there is encroachment by a third party near to his land, which is adjoining land, which is affecting his, which is detrimental to his public interest. Therefore, if such an exercise is done, might would help the revenue authorities and the district administration to prevent further enforcement of any further land or from preventing unauthorized construction to come up on the land which may belong to the deity. Next. All the appealing parties are at liberty to state council as well as appealing parties are permitted to send a downloadable copy of this order to their respective parties. Next one. Response at same date after 2 weeks. 79.
Only one clarification. This aspect pertaining to encroachment, I had brought that on record to another IA, that is IA 2068. So both IAs can be mentioned.
Last part where it said encroachment, which is which is the subject matter of IAS
2068 of 2026.
2026.
Most of that.
22nd, 7 people more. 22nd. 22nd.
And there was a mention about that interim application that would be registered, but it will come in the meantime.
Yes.
So whenever it comes,
Yes.
we'll take it up.
Can it be on 22nd? 22nd was the 17th, I forgot.
So then, all villages would be. That's hills, you can take it, constituting three hills of Bhubaneswari, Kamakya and Bora, BURAH. And Durga Sarovar. Sorry, Bora and Durga Sarovar.
These are three villages.
Hills.
For revenue records, it's only Kamakya, Your Lordship, only Kamakya.
Huh?
Only Kamakya,
No,
revenue
Durga
village.
Sarovar is also a village.
No, revenue, and Durga Sarovar falls within the revenue village. Kamakya, Your Lord.
Have a doubt.
That is what was mentioned in the 1973 Jamabandi, Your Lordship, and which was later on lost, Your Lordship. They named it the Sadar Jamabandi, Your Lordship, which included only revenue village Kamakya.
Then I also try to find out from the revenue authority.
No, I vaguely remember because in my earlier days there were some litigations which
Required mention the revenue village as
which
Durga.
went beyond Durga Sarovar as a village,
In the I also they have mentioned Durga Sarovar as a village.
as a village.
Okay. In his I
I also in reading we have mentioned, Your
in the
Lordship.
prayer
but
portion
that
in his
particular
IA,
Jamabandi-
You should have known better.
No, no.
It's for the,
Lordship, but the Jamabandi of 1973, which pertains to this case, Your Lordship, which was lost. Only Kamakya village was there, Your Lordship, and that they mentioned as the Sadar Jamabandi, Your Lordship.
you see, so far as,
The entire land is concerned, then it will come,
so far as the memory I retain, from 73 onwards till today, no new revenue village has been created in Gauhati.
and in the meantime, I'll try to find out what is the exact status.
No new revenue village. It's all the existing village where this we are being held with. Revenue village extension has not been made. As far as my memory goes, I may be wrong.
22nd map.
22nd. 22nd. 22nd.
ठीक है. 22nd. Obliged. Right.
Item 4 for hearing.
What do you mean?
Please, Your Lordship. So before starting, I would like to just point out one thing. The order dated 5/6/2024, Lordship. As per that order, Lordship, there were total 5 petitioners, Lordship. 1, 3, 4, and 5 are already declared to be Indian citizens, Lordship. And no, not declared, but their name has been struck off. And yeah. Yes, sir. So now, Lordship, this is only with regard to the petition number 2, Lordship. Yes, sir. So now, the entire Lordship, can you turn to page number 38, Lordship? That is the impugned order, and the court below, Lordship, the tribunal has adjudicated upon all the things as Mayamoti Nama Sutra, Lordship, not as Mayamoti Viswas. Now, why I'm saying so, Lordship, is because Lordship, kindly, if Lordship turns to page number 79 of the LCR, Lordship. Okay. That is the report of a Gauhati. As per report of the Gauhati, Lordship, there is no person by the name of Mayamoti Namasudra, Lordship. And the entire proceeding before the court below was against Mayamoti Namasudra, Lordship. In that lordship, we have filed a written statement as Mayamoti Biswas. On my written statement, lordship would find at page number 103 of the LCR lordship. PCR lordship. In that, I had to sign as Mayamoti Namasudra alias Biswas because the name appears in the court below as Mayamoti Namasudra lordship. In fact, in the Vakaratnama also, I have signed as Mayamoti Biswas also. That is, lordship will find at page number 107 of the TCR. Opinion is a page number 39, Lordship, of the writ petition, Lordship. May I read, Lordship? 39, the operative part, Lordship. Point of determination. May I read, Lordship? No, I have filed a written statement, Lordship.
You find it in a statement.
Yes, Lordship,
We
that is
see
what,
only of 224, we don't see of yours.
no, it is on page number 103 of the OTCR, Lordship. It was filed on 5/12/2016.
103.
103, Lordship. There perhaps the signature is given as Mayamoti Namasudra alias Biswas, as far as I remember, Lordship.
But Mr. Lekha, we can still not help you.
No.
The reason is that you did not turn up to give evidence.
That
Trying to
is,
search, but the evidence is not there.
that is there, no. That lordship would find that relevant, if I may just point out in page number 39, lordship,
Page number,
39, lordship, that opinion, lordship,
yes, we have seen that.
that Mayamoti Biswas is the daughter of late Dinesh Chandra Biswas, exhibit means I have exhibited.
No,
In her evidence on affidavit, this is I'm reading from the opinion, lordship.
But in the businesses, but in fact, she had not exhibited the documents and has given return along with the affidavit.
Yes, look, that is what I was trying to read, lordship. In her evidence on affidavit, this proceeding stated that all these documents are exhibited, but in fact, she has not exhibited the documents annexed in her written statement along with the affidavit. Therefore, these documents are not admissible as evidence under law.
correct.
That,
What
that,
she does is that she has filed a written statement. The written statement of 1, 2, and this 2, 3, 4. Statement of 2, 3, the written statement of 2, 3, 4 contains documents which are marked as exhibits. That is there, page 111 of this record.
lordship.
And this present petitioner she, along with her written statement,
Yes,
has referred to 4 exhibits.
lordship. That probably lordship would find that at page number 98, 97, 96, and 88 of the TCR, lordship.
Yes, written. Timing, and become an idea. These are And
Section 3(1), citizen to move it along. C1.
itu lagi dikira mana W lagi who's the difference? Tapi baru makin berkurang. Tapi bisa saya saja lebih. They should document the. Okay.
Lordship, there is also a rehabilitation certificate in page number 94 of the TCR. Lordship.
And any thought with the opinion? What is the opinion? You have checked the records, because since you know the pages, you have seen the record already. The documents are not exhibited.
Lordship, I understand, Lordship, may I just last try, Lordship. The entire proceeding happened on the basis that that person is Mayamoti Namasutra. No attempt was made to determine whether it was Mayamoti Biswas. Now, because of this reason, Lordship, the entire adjudication is not correct, Lordship. Because, Lordship,
Come to page 40, that is discussing the finding. At the end of paragraph 1,
Lordship,
four lines,
Lordship.
which are not done by these proceedings. The proceeding has not proved that their surname is Biswas instead of Namasutra. The annex documents are in the name of Biswas. That is why annexes cannot be construed that these are their documents.
That is the reason, Lordship. That is my submission, Lordship. That finding itself is wrong, Lordship.
Right, because no attempt has been made.
No attempt has been made, Lordship. So even though your Lordship is sitting in a tertiary jurisdiction, Lordship, if Lordship can help, at least with regard to this finding, Lordship, then.
Know what has been done. In your written statement,
Lordship.
you refer your name as Namasutra Urfe Biswas.
Exactly, only a sign signature. But in Vakaratnama, I have signed as Mayamati Biswas. That Lordship would find in page number 107.
How do you come out of it? You admit that you are Namasutra alias Biswas.
No, Lordship, I am Mayamati Biswas, Lordship. Because I had to sign it as Namasudra because the procedure, my name is reflected as Namasudra and I have been summoned as Namasudra. That is why the alias was made. But all practical purposes, my name is Mayamoti Biswas and all the certificates I have produced in Biswas, Lordship. Only for the purpose of this case, I have signed it like that, Lordship. Suppose today my name is Mayamoti Biswas and it is written as Namasudra. If I go to and do an affidavit, that affidavit may not be accepted also, Lordship.
I don't know, but just because of my mistake in addressing you as Mr. Dekha, I call you Mr. Saikia. Not make you Mr. Saikia. You can't appear and say that yes, when the court suggested my name to be Saikia, I start.
Correct, but if my only point was that the adjudication and Lordship has rightly pointed out in page number 40, that is where I'm against, Lordship.
The certificate of the rehabilitation branch is not a certificate of registration as a citizen.
No, it is not, Lordship.
So unless you show that you have been listed in excess of power vested under section 5(1)(a) and 5(1)(b),
Lordship, I am supposed to be, Lordship, if I'm understanding things correctly, Lordship, I might be a citizen under section 3(1)(a) of the Citizenship Act, Lordship.
May not be. The reason is that once the reference is that you are a foreigner, you see, your reference was not under the Foreigners Act.
And
Your reference was under IMDT.
Lordship,
If you read section 8 of the IMDT, the reference would only be to the extent as to whether he is a foreigner.
Lordship.
That does not have the stream. Stream comes from the 1955 Citizenship Act,
Lordship.
specifically in relation to the state of Assam. Then under section 6(a), you get this. Section 3 is ousted when you are once proceeded against as a foreigner.
Under the IMDT,
Once you were proceeded as a foreigner,
Lordship.
then by implication section 3 would be excluded. Unless you can show any authority on the point that despite being proceeded as a suspected foreigner, still can have the benefit of section 3.
Lordship, that aspect I have not seen. If I can see and
Come to our notice. So this reference, all these references were transferred by Supreme Court and before the foreigners tribunals. But still the prosecution would be under Procedure section 8, which is now covered by 2(1)(a) of the Foreigners Act. The foreigners, the 2(1)(a) of the Foreigners Act, who is a foreigner.
a foreigner means a person who is not a citizen of India.
Here you don't have the date. Okay, let us take it up at 2 o'clock.
Lordship.
Take it up again. This with a fresh mind.
Lordship.
Take a break and come back.
Yes, Lordship.
Time being item 2, WP Criminal 28/26.
My lord, record has come, my lord. If it pleases, my lord, may I kindly do my part of the hearing? Detention. Why? Oh, yes, definitely, sir. This come. Next. Thirty is my lord Sunday. Sunday, subject to corrections. 30 August is Sunday. Or 31st. Always. 28th or 31st. I was just asking you. 28th or 31st. 28th Friday. You must be aware that it will be required to produce record.
We expect that it will be. That is why I wait for the time.
Item 5.
Yes, 30 is November. Okay.
Document that is a N and O. Whether this document.
These are all the records and page. Page ballot is 69 in my petition. This is the picture. This is, I think, exhibit M. So, given the statement is page 14. Hello. philosophically, is the improved opinion. Page 38. Have we exhibited examiners, exhibit A to exhibit O? And those particular lines originally belongs to his her father. And after that, the name of the petitioner and along with her other siblings were notated. And she also paid land revenue. Let us clearly see. The petitioner exhibited a voter list of 1970. And he also mentioned in the written statement that his father name also appeared in the voter list of 1965. But photocopy has been annexed. But in written statement, it also clearly say paragraph paragraph 35, madam. 35. Yes, madam. The local verification officer clearly mentioned in his report on Annexure A, clause number 15, that the opposite is not migrant into Assam. It is this Annexure A of the reference case, not format or verification officer's report. In clause 15, whether migrate to Assam, here, yes or no. 35, 19. Paragraph 30 of my written statement. Yes, madam.
Yes.
The local verification officer clearly mentioned in his report on Annexure A, clause number 15, that the opposite party is not migrant into Assam. Now let's look at that Annexure A, it is on the record. Clause number 15. Whether migrated into Assam, yes or no. Tick mark given in no. Yes, Annexure A of the no record in a reference case. Dari kata naik, enak sekarang langsung. Now, in my evidence, page 25, evidence in the page 25. My lord, 30.
Please continue.
Now also can see page 27 of my petition in evidence in chief. Yes. Annexure to page 22 is my evidence in chief. 22. Page 27, paragraph 35. 35. Yes, 27. Yes, paragraph 35. That the opposite has submitted photocopy of the voter list of 1965 with the written statement. And also today, I am again submitting the photocopy of the said voter list due to non-issuing the certificate copy of the said voter list by the election authority of the district, which already I have applied through my appointed advocate by application number so, and hence it is utmost necessary to call the election authority of the district for authentication of the voter list of 1965. I made a statement, I could not bring the certificate copy along with my written statement as well as evidence in chief. And page 34 also mentioned this is a permanent resident of Hilsar Farm, Bhavra district. Is my permanent, but my son is residing in a Swarbu in village Nisoka. When we visited to my son's house, then the police registered our name and case has been registered. But we are originally resident of village Hilsar Farm. Now, my lord, subsequently, my lord, I obtained the certificate copy of the voter list of 1965. And I filed an additional affidavit, my lord. Subsequently, I obtained the certificate copy of the said voter list of 1965, page 62. I annex here for consideration, my lord. Page 82 of my petition. This is the voter list of 1965. We obtained it on 21/11/2019. 1965 voter list, my lord. Impung opinion is dated 28/8/2019. After pronouncement of government, I obtained the certificate and annexed it for consideration. Here, my father's name and mother's name appeared, along with my brother's name was also appeared, along with my father and mother. And I, in my written statement, my provided my family tree details in details. Now also can you the Gaura he issued a certificate, he was examined as DW2. Lordship kindly his examination. That certificate, none is after promotional work. My lord? No river file. Yes, here I said for consideration. My father's name is Jivan Mia. Jivan Mia. Mother name is Poiskar Nesa. No, I am not eligible for voters. My one sister, Jagan Nesa, is 21 years. My height, Alimia, 25 years. My brother. I mentioned the name is a written statement as well in the evidence matter. Now, Gauhati has been examined in this case, my lord, who issued the certificate. And his statement evidence is on page 33, relevant page 34. Honorable my lord. Page 34, DW to Gauhati. My name is Dilwar Hussain, son of Lekot Hikmat Ali, village Hilosar Farm, Spencer. One note, exhibit to moi dia certificate, আৰু মই এই certificate হাজিৰা কাৰণৰ দিছো। দ্বিতীয় পক্ষৰ দেউতাকৰ নাম জীৱন মিয়া, দ্বিতীয় পক্ষ হিলোচাৰ ফাৰ্মত থাকে। দ্বিতীয় পক্ষৰ মোহাম্মদ আলীৰ ল'ৰা 90 চালিৰ লগত বিয়া হৈছে। Exhibit L to his signature. Then PW3 is the Lat Mandal was also examined. I am page 35. I am Lat Mandal at Hilosar Farm. The land cover, Dagnoa Senso Patanabo Senso has been mutated in the name of Hajira Khatun and her brothers and sisters has legal heirs of their father Jivan Ali. Exhibit 01 is the signature of the certified cycle officer, Crow Tribunal. Exhibit O, the government land was mutated as Medipata in the year of 1983-84. Before that, the said land was under the possession of Jivan Ali, my father. It is not recorded. There is no share of land stated in the record. There is no record in the office about any inquiry report before mutated in the name of Hajara Khatun and her fathers and sisters as legal heirs of late their father Jivan Ali. So those evidence as well as those exhibited documents were nowhere silenced at any point of time. We are not questioning it. Evidence as well as those documents. Now I file an additional affidavit. Additional affidavit. Here I put an exam voter list. Those documents are also not available at that point of time. Exhibit page 7, it's 1985 voter list. Here, name of my father, mother, and my sister-in-law were appeared. Page 7 and 8. Then the voter list of 1989 of Sam Bilasan. Name of my father and mother appeared. Then voter list of 1997. Name of my father, mother appeared. And voters were living separately. That is why their number of recorded.
In this case, I found that the learned council has probably filed a grievance statement in this particular case.
Observe that there is this pair of economics is also not mentioned in the record and there is no reference to page 41 of the order. 41. First para. First para from bottom. Not 69 from bottom. This pair of economics also not mentioned in the record and there is also no record in the office about the entry made at the time of mutation in the name of proceeding second party as a right of inheritance. From the evidence of PWP, it is clear that there is no record in the office regarding the application or the documents filed by the
Opinion.
opinion. Same evidence has been given by the lordship. Although murder was alleged after death of the father, murder sin was not mutated in this law only law. The evidence of this 31.
Opinion.
Item 8 ballot. Item 8 na, maybe taken on next Tuesday or Thursday ballot. But at 2 p.m. ballot, I leave the court ballot because of my subject. Item 8 ballot.
There is consistency except for that spelling mistakes somewhere, different spelling for 2 or 3 names. Okay.
Regarding Jomavati of support, I believe that was very numbersly discussed about all the experiences process. And in respect to process, a Jomavati is under exhibited documents process for proceeding as exhibited process from exhibit A is the NRC details process, exhibit B is the 1970 footer list, and exhibit C is the 1992 footer list. And process between these period process, there is no document. No document has been sent by the proceeding authority between this period, 1970 to 1993. After that, 1997 footer list that was discussed by the tribunal, then continuity was not there in respect of the proceeding. After that, 1997, 2008, and Air Lordship, although 1965 footer list was mentioned, it was not placed before the tribunal Lordship. And Lordship, in respect of Ramapalli Lordship,
Page 41, Lordship. Proceeding second party exhibited Chita copy of land, page 41, Lordship. Proceeding second party exhibited Chita copy of land as exhibit M and exhibit N, and also exhibited Jamabanti copy of land as exhibit O, covered by part number 120, tag number 3682768 and claimed that proceeding second party's name along with her brother and sister's name committed after death of her father. Proceeding second party to prove the Jamabanti copy examines last mandal of Shortwave revenue circulars DW3. DW3 in his evidence in chief stated that in the pasta number 120, that number 3687681 in case of father Jiban Ali, proceedings second party Hajara Khatun and her brothers and sisters names mutated as a right of inheritance. On being questioned by tribunal, DW3 deposed that in the year of 1983-1984, land is converted into Miyadi Patta in the name of Jiban Ali. But in the record, it is not mentioned from when the land was in possession of Jiban Ali. This share of Jiban Ali is also not mentioned in the record, and there is also no record in the office about the inquiry made at the time of mutation in the name of proceeding second party as a right of inheritance. From the evidence of DW3, it is clear that there is no record in the office regarding the application or the document filed by the proceeding second party at the time of mutation of name. So, Lordship, in that regard, Lordship, tribunal has rightly just that Lordship rightly observed that prior to 1984, there is that land was who was occupying that land that was not mentioned in the record, and only statement is not enough, Lordship. So he has to prove that Lordship he is occupying that land since 1966 or prior to that, Lordship, or since 1970. So that was not there, and Lordship.
See, that is not the case of the petitioner.
Yes.
The tribunal asks the wrong question and the wrong answer is taken. You see, number one, this Lat Mandal comes and deposes. Was he asked to bring the records? No. Therefore, when he says that it is not in record, would mean that record is only of the Jamabandi. Now, please tell me how settlements are made. Today, if you want to apply and get a land allotted in your name, what is the procedure? You must be in possession and then apply. So, in the Jamabandi, you will never get, or in the Chitta, you will never get it. You will get it in the allotment order. Correct. So, a wrong question is asked and wrong answer is given. Thirdly, assuming that A has a land and there is an entry in the Jamabandi which does not say that he is in possession. I have never seen a Jamabandi where the issue or Chitta where the question of possession is written. But assuming it is required to be written. So if it is not written, will it make a person a non-Indian? No. The first voter list is of 1970. In 1970, he says that it is the name of so and so. And then he brings a 1984 Jamabandi saying that this is my father, the same man in 1970, and his legal heirs are this one. So therefore, the linkage of the petitioner with the father is there from that Jamabandi or Chitta, whatsoever. And lack of that, the entry in the Jamabandi would be sufficient to dislodge the citizenship. Now you read this part again.
But Lordship, entry in the name of Jamabandi, Lordship, it does not prove one citizenship, Lordship.
No, it's not that. But if you connect it with 1970, then the only difference is Ali and Mia. In the written statement, they give the names of everyone. Javamanti has everyone. Can you see the reference, which year that reference was there?
Reference not to IMDT reference.
It's an IMDT reference. Made when?
And all. The ARO, nine. ARO reference. ARO reference. IMDT.
You have to learn. You have to learn it. IMDT, you have to work with that. You have to learn. Info moment into IMDT number, you have to learn. Okay, yeah. Okay. Okay. Now, should I? Can you read this page 80? Or should I show you how to read the land documents?
Sure.
Come to page 80. This is, I can tell you for sure, with some experience I have gathered, that many of the lawyers do not know how to read a land document.
Yes, sir.
And therefore they make a mistake because of the fact that they know how to correct.
Yes.
Even if they have documents, they miss it out how to read this document.
Yes.
So it is only that. Come to page 80. First is the Notun 120. Correct? Pata is 120. Now read the first remark. 201 oblique 83, 84 number মেয়াদী দরখাস্তৰ
উপপ্ৰতি সমাহৰ্ত
so ইমান 85 তাৰিখৰ হুকুম মতে 768 দাগৰ 2 বিঘা 1 কঠা তাৰপিছত 2 কঠা 2 কঠা
2 বিঘা 1 কঠা
16 দাগে 1 বিঘা 4 কঠা পেছা ইমান দাগৰ এই বিঘা ইমান কঠা ইমান পেছা ইমান মাটি 14 বিঘা 1 কঠা 18 লেচা মাটি প্ৰিমিয়াম আদায় হোৱাৰ 1 নম্বৰ জীৱন আলি 2 নম্বৰ আলোজফত number 3 Asanuddin.
Yes.
Number 4 Sri Ramesuddin Pita so and so iman swami iman বন্দোবস্ত নতুন 120 নং মেয়াদী পাট্টাৰ ভোগ কৰা হল. That means this is the first allotment order from the authorities and this name is mutated. So these 4 names are the persons who 1, 2, 3 and it is 1, 2, 3, 4, 5. 5 people are there as original patadar. Then whoever name comes later are some additions under remark number Q. Chithar iman joge iman ahil. Correct. So this is the first allotment order in the Jamabandi. And as we have already told that you get the land allotment only when you are in possession of a land which is under the land policy it was then. It should be a wasteland. You don't get a town land or good land when you are applying for this. Under the land revenue regulation, the rules require that the land has to be a wasteland. Correct?
Yes.
So 85 is not material when it was done. The fact is that after this, these names were inherited. By inheritance, it has come. So therefore, if the father's name is there in 1970, that father's name is there. 7 except that Mia and that Ali. Then there is a link. All throughout, they have disclosed the names of those persons only. Therefore, the question to that allotment was wrong. And this, you look at it, all this 1, 2, 3, 4, 5, they are sons of Jahir Bepari. So is it required that in your house, you and your wife, you will have to divide the area 50-50 and then say in the flat room number 1, I will stay, room number 2, you will stay? No. So in the brothers, there is no requirement of any division. So why do I need a share in 14 bigha land? You don't need a share. You did not have a partition. So therefore, the presence of share or absence of share would not make a man a foreigner.
Yes, sir. I am sorry, my lord. I am understand the today I learned about it. But
No, when you get the document, you'll have to read it.
yes. But I want to give once more. Now, and another matter.
So just what you are saying.
More submission, Lordship. I may be wrong, Lordship. What in case of Jamabandi, what Honorable Court has observed, Lordship, in this case, Lordship, WPC 4653 of 2020. Four, 4653 of 2020 Lordship, para 36.
Yes.
The petitioner has, para 36, Lordship, I am reading. Petitioner has also relied on the Jamabandi copy marked as Exhibit D. However, it has been correctly held by the tribunal that the evidence reveals that the petitioner's father died in the year 1983 due to mishap in boom blast, whereas there is no evidence that his mother had passed away. But the petitioner's mother's name has not been inserted as legal here relating to the property appertaining the number so and so at Kopunik place. So, Lordship, my humble submission is that although immediately after death of the father, Lordship, all the concerned persons' names are inserted, Lordship, in this Jamapundi. But although mother was alive at that relevant period of time, Lordship, mother's name was
The aggrieved party.
Lordship.
Who would be the aggrieved party?
Lordship, Lord.
It is the mother,
Yes, Lord.
correct? Have you ever inquired whether the mother wanted the land for herself? She may say that, yes, I don't need a share, all the sons divided. That's not that bad. It happens in all our families, in very close relations of mine. The mothers or sisters, they have relinquished land. They are happily married, the ladies are happily married, despite the 1955 Act entitles the ladies to share. Many in our families have relinquished. And you see, that entry would not be in the Jamabandi. Please try to understand that order would only be in the mutation order. There the circle officer will write that the eight persons are the legal representatives, out of which 5 are sisters. They have given their no objection to the mutation of land in favor of 3 brothers, and therefore that has been mutated. If somebody is wanting that entry in the Jamabandi, you'll have to teach. Ms. Bordole has gone, or Mr. Sorry, no. Standing counsel for the Borfujari.
Oh, Borbudariya.
They will have to be given a lesson that
Yes.
everything has come here. It doesn't come.
Under in the reference case, annexure A, let's see. The clause for date of birth 1970 mentioned. He also mentioned she is 1970. And paragraph 8, clause 8,
Lecture A.
yes.
Lecture A doesn't help you.
No, I'm not my petition, reference case. Reference case.
No, that is merely your disclosure.
Yes, no. And 8, whether the father is registered as an electoral or any person in India? Yes.
No, that doesn't help you anyway.
That was already settled, Lordship. So many decisions have been passed by court also.
No, we'll find out the answer here only. Come to your, come to page 14. Right, turn over to page 15. You said that you were born and brought up at so. This annexure A, you are aware of it because you have written that in your written statement. Despite knowing your date of birth mentioned in that annexure A, in your written statement, you don't say that my date is my date of birth. So how would
Not
that be helpful to you?
Yes, not mentioned. But PAN card, she mentioned.
If you knew the PAN card, we must give the date here. That is our judgment.
Yes.
We are following it. Since 2019, we are following it, that if you have a PAN card, number one, you are not a income tax paying.
Income tax.
You get this PAN card in 2013. It is issued after 2013. When did you get it?
Page 59, maybe.
What is the date of issue?
It also located by. No difference.
Generally, EPIC was issued after 2013.
Yes. The date of issue is not there.
They're not there. Date of birth mentioned.
Yes. So despite knowing this, you don't give your date of birth in your written statement. That we have rejected long back.
Well,
Even when you are relying on, come to page 18, when you are relying on your PAN card, then also you don't say your date of birth.
yes. Well, it's plus 65. Well, yes. 65. That's all. No, photocopy, my lord. I also produced photocopy before the tribunals 2 times. In written statement and certificate were not furnished, then in evidence, I specifically mentioned that I specifically mentioned in my evidence, my lord. Paragraph 35 of my evidence, page my lord, page 27. 27. Paragraph 35. The observer has submitted photocopy of voter list of 1965 with written statement, and also today I am again submitting application for I have the copy of that application also. Copy of the application also. I applied for the certificate copy. Additional video for the additional video. And I also annexed voter list of 1985, 89, and 97 by filing additional affidavit. Continuation is there. Right. Well, your lordships, and you may, lordship, allow the petitioner also to exhibit the voter list of, well, in this regard, one, yeah. Well, one order passed our this noble court in this bench of this noble court. Yes, madam.
The petitioner has, a petitioner namely so and so has assailed the opinion dated 28/8/2019, passed by the learned member from a foreigners tribunal number 8, page 38. Passed by so and so in case number so and so, by which the petitioner declared to be a foreigner post 25 in 1971 street.
No.
The petitioner, on receipt of the notice of the proceedings, appeared and filed a written statement.
In similar nature of case, this noble court given opportunity to the petitioners to produce all those documents, obtain the certificate copy.
No, this order doesn't help you. In this case, what had happened was that you produced these
1 year.
photocopies.
Anyone, sorry.
You did not produce the documents which were
Photocopy here.
which are certified copies. So this court, while discussing, found that your what you call your father was declared to be in this case.
Sambotalis could not
The brother
obtain.
was declared as an Indian. So in light of that, the court examined the records and then found out that you had produced photocopies and not the certified copies. So therefore, this court sort of reprimanded, saying that at no point of time petitioner should place uncertified copies of voters before the learned tribunal. And therefore, you were the court directed you produce the certified copies.
And
Does not mean that the additional copies were permitted.
we would file additional affidavit annexing those photocopies here, my lord. We have not produced those documents there, my lord.
So only that was allowed. The court did not allow you to give any evidence beyond what was there on record. But no. You made us unnecessarily read 11 pages.
Right. But one chance given, I produce here the relevant documents, my lord, 65.
We'll consider that. What we have produced before us, we'll consider. Why should we ask the tribunal to consider what is before us?
I put this here, my lord. I put this here. So those documents, by, by filing additional affidavit,
That will be automatically rejected.
by filing additional affidavit, I put this here, my lord. It is up to the lordships, my lord.
In the written statement, the petitioner took a plea that the name of her grandparents is Jahir, Jaher, Jahir Mia and Sibaran, Sibaran Nessa. And the name of her parents is Jivan Mia, Jiban Mia, Miya, and Poriskar, Pariskar, Nessa. He projected herself to be married to one Mobes, Mobbes, Ali. She had pleaded that the name of her father appeared in the NRC of 1951 of village Helochar, Helochar, farm. The name of her parents and brother appeared in the voters list of 1965 and 1970. And her own name along with her husband's name appeared in the voters list of 1993, 1997, 2008, 2010, 2011, 2017, and 2018 of the same village. It also relies on the electoral photo identity card within bracket EPIC for short and PAN card issued by the income tax authorities. Mr. claimed that as per the Jamabandi, on death of father, the name, her name along with the name of her siblings was mutated in respect of the land. The following in support of a defense, the petitioner had filed her written her evidence on affidavit, wherein she had reiterated the stand taken in the written statement and exhibited the following documents. That list is at page 39 and 40. Exhibit A to Exhibit O. The petitioner had also examined one. What's the name of DW2?
Dewan Delwar Hussain.
Huh?
Delwar Hussain, son of late Hikmat Ali, Gabura. Page 34.
Okay, from Dilawar Hussain, the Gangura as DW2. Which stated that in his certificate, the name of the father of the petitioner appeared in the voters list of 1965, which was not enclosed, which was not found enclosed with this certificate. The petitioner had also examined what is the name of the Lat Mandal?
Asghar Ali.
Asghar Ali, for the Lat Mandal of Hathebari, SARTHEBRI, Hathebari Revenue Circle as DW3, who had refer to the mutation of the name of the petitioner and other brothers and sisters in respect of the land of her father. Next. The learned tribunal had rejected the evidence of the DW's in respect of the Jamabandi, in view of the response given by the DW3, that in the record it is not mentioned from when the land was in possession of Jivan Ali. And there is no record of inquiry made at the time of mutation of the name of the petitioner as right of inheritance. And moreover, the name of the predecessor in interest of the petitioner was referred as Jivan Ali. And there being no explanation regarding the name discrepancy of the father of the petitioner, which is written as Jaher, Jaher, Jaher Mia. Oh, Jivan Ali, Jivan, J-I-B-N.
Jivan is son of Zahir Byapari.
Jivan Ali, whereas in the deposition, the name of the father of the petitioner is referred to as Jivan Mia. It was held that so far as the grandfather's name is concerned, or there was no evidence to prove that Jahir Byapari, Jahir Byapari, B-E-P-R, and Jahir Mia is one and the same person. And therefore, Jivan Mia, son of Jahir Mia, and Jivan Ali, son of Jahir Byapari, cannot be relied as one and same person, and accordingly, the copy of Chitta within bracket Exhibit M, a copy of Jamabandi within bracket Exhibit O, and Exhibit K within bracket then you will receipt. The Cowbra certificate within bracket Exhibit M is held not enough to prove the case of the petitioner. The NRC within bracket Exhibit A was instructed as it was print out of the NRC tables. On account of the fact that there is no authentication or certification by the competent authority. Accordingly, the exhibited voters list were not found to prove that the petitioner or his father or his or his projected grandfather were citizens of India. More so because the petitioner in her written statement had, as well as in the evidence, had referred to the name of her grandfather as Jahir Mia. Certainly, the other exhibited documents are also not found helpful for the case of the petitioner. Accordingly, the petitioner was declared to be a foreigner post-25 in 1971 street. Next. The counsel for the petitioner, amongst others, had submitted that in the written statement, at paragraph
Evidence in C, paragraph 35.
evidence in the page
Page 27, my lord.
in paragraph 35 of the evidence on affidavit filed by the petitioner, she had stated that he had submitted photocopy of the voters list of 1965 with a written statement, and along with the evidence on affidavit, she is again submitting a photocopy of the said voters list owing to non-issuance of certified copy by the election by the concerned authorities. And it is submitted that she had stated that she had applied for a copy of the voters list of 1965 through a advocate by the application number capital SSDC ED CCER 133-1344 dated 8/5/2018. In this regard, the learned counsel for the petitioner has produced before this court a photocopy of the acknowledgement receipt of the application for certified copy of the voters list of 1965 submitted on 8/5/2018. So it is submitted that the said document was obtained after the on 21/11/2019, after the opinion was issued by submitting another application dated 21/11/2019. By referring to the said document, it is submitted that the said document would establish, would be helpful in helpful for the petitioner to prove the discrepancy in the name of her father and the grandfather. It is further submitted that the petitioner has few more documents to be exhibited in the event the court permits remand of the matter. Next one. The per contract on the learned standing for the border and FT matters. Achha, just hold on. Has referred to the decision of this court dated 15/6/2026 passed by this court in the case of Saidul, Saidul, Saidul Rahman, alias Muhammad MD, Saidul Islam, WBC 5250/2019. Next, per contract, the learned standing counsel for the border and FT matters has made its submissions in support of the impugned opinion. Full stop. It was submitted that the learned tribunal had correctly read the Jamavandi, and as the said document is of post 25 to 1971, the same was not found sufficient to prove citizenship of the petitioner. To stop. It is also submitted that the learned tribunal had assigned reasons for discarding the Jamavandi on account of the fact that it does not allocate share to the various patadars. And then the name of the father in the projected father of the petitioner in the Jamavandi is not Jivan Ali, is not Jivan Mia, as stated by the petitioner in a written statement, but the name of the patadar is Jivan Ali. So accordingly, it is submitted that said document was not a proof of Indian citizenship of the petitioner. Similarly, he has referred to the finding of the learned tribunal on other exhibits and has supported the discarding of the documentary evidence of the petitioner by the learned tribunal. He also stresses on the lack of record stated by the DW3 in his deposition with respect to the land over which the petitioner got the right of inheritance. Moreover, it is submitted that as per the evidence available on record, the mother of the petitioner was still alive, but she did not inherit any share in the land. Next one. having considered the submissions and as well as the records of the learned tribunal, it is noticed that that in the evidence on affidavit, which was filed by the petitioner on 14/6/2018, the petitioner had mentioned in paragraph 35 thereof that the photocopy of the voters list of 1965 was filed with the written statement, which was resubmitted along with the evidence on affidavit. And the application number and date referred to in paragraph 35 appears in the photocopy of the said application form, application receipt produced by the petitioner before this court. From the said document, it appears that that someone on behalf of the petitioner had applied for the certified copy of voters of 1965 under acknowledgement number. Sorry, acknowledgement, application number, not acknowledgement, application number. You copied from there, SSDC, same, so and so dated 8/5/2018. You get a photocopy in the meantime,
Well,
give it up. I don't record. It will be the learned counsel for the petitioner directly to provide a photocopy thereof for the record, for making it a part of record. Next. Without examining the merit of the photocopy of the photocopy of the voters list of 1965. As the learned counsel for the petitioner has submitted that the certified copy of the voters list of 1965 has been received and annexed to this petition. In the considered opinion of the court, the petitioner has been able to make out a case to enable him to have a right, to get one opportunity to post the voters list of 1965. A photocopy thereof of which was produced along with the written statement, as well as the evidence on affidavit. Next up. Insofar as the fear made by learned counsel for the petitioner is regarding additional documents required to be proved is concerned, the court does not find that the case of Saidul Rahman alias Muhammad Saidul Islam come to the aid of the petitioner in any manner. In the said case, the objection was that the father of the petitioner of the said case was declared to be not a foreigner. And this court took note of the fact that the petitioner, while contesting the proceedings, had produced uncertified copies of the voters list. Yes, sir. Accordingly, this court, while not approving Submission of the uncertified copies of the voters list before the learned tribunal, granted the petitioner therein one opportunity to produce the certified copies of the document of the voters list referred therein. Facilitated a fresh opinion. Therefore, the said authority, the said decision is not an authority on the point that merely because the petitioner has left out to exhibit any document before the learned tribunal, would be given an opportunity by this court in exercise of certiorari jurisdiction under Article 226 of the Constitution of India. Next. No, not to continue. So therefore, the prayer to enable the petitioner to exhibit any further document was rejected. Save and accept in respect of the voters list of 1965. Next one. Accordingly, as the court finds that the case of demand has been laid out, the court is not supposed to examine the any other issue on very as it could prejudice the petitioner by leading of fresh evidence in respect of the voters list of 1965. Next. Resulting to come up the what is of the constitutional opinion that which I know just before that you say according to the court of the constitutional opinion that the matter be in fact to remand the matter back to the said learned tribunal just to give an opportunity for the petitioner to the voters list of 1965 certified copy of the voters list of 1965. In order to facilitate the same, or the court is inclined to set aside the given opinion dated page 38. You can open it also, our questions also. Next one. The petitioner, is duly represented by a learned counsel, is directed to appear before the said learned tribunal on or before the outer time limit of 30 September 2026. So on the said date, on the date of appearance from the petitioner shall file an additional witness statement on the respect of the voters list of 1965, and he would also present before the said learned tribunal an additional evidence on affidavit along with the certified copy of the voters list of 1965. Next paragraph. Thereafter, the learned tribunal shall hear and dispose of the matter in accordance with law. Keeping in mind the time limit as prescribed under the under section 70 within bracket sorry, 17 within bracket 14 of the Immigration and Foreigners Act from 2025. Which supersedes the foreigners within bracket travelers practice order, 1964. Next paragraph is made clear that in the event the petitioner does not appear on or before the time allowed, the opportunity granted to the petitioner will be lost, and it would be open to the learned traveler to treat the petitioner as absent on call and pass a fresh opinion in accordance with law, without being influenced by any observation made that has been made in this order. Next part, the registry shall return back the travel's records of the earliest, along with a copy of this, downloaded copy of this order, to be made a part of the record of the said learned travel. It just stands allowed to the extent is indicated above with an order of remand. We should know what is cost.
High level.
Yes, Mr. Dekha, will take up your matter.
My lord, I would like to also point out one thing, my lord, in the LCR. If lordship would take up the PCR also. Dada. Kishorida. If my lord would take up page number 12. Lordship, can you take up page number 3 first? 3. This order dated 24/4/2016. From that, the court was of the opinion that the surname may not be correct and these people may not be correct. And then he went on to pass an order dated 10/8/2016, and he directed the SP to conduct an investigation and submit a report. And in page number 4, order dated 10/8/2016, the SP has not filed any report. Without that report, he went on, lordship. And in page number 12, that order regarding title, so it was never ascertained that with regard to that title, whether that is Namasudra or the reference was drawn to a proper person, that report never came, and that with regard to that title was always absent. That entire exercise was not carried out, lordship. And subsequently, one Deepak Biswas, he appeared, seeking time. And that is what I found from the record. Now, in the Wakalatnama, Lordship, I have put that right thumb impression. Now, that writing part, Lordship, could not have done, Lordship. And then again, in the written statement, in para number 3, in page number 103, I have specifically written that I am Biswas. But the signature, there is no signature of mine. It is only a thumb impression. And that written that Mayamoti Namasudra alias Biswas, that could not have been written by me, Lordship. And in the affidavit also, my name was Biswas only. So me saying that I am Namasudra that is not correct, Lordship.
Surname Biswas may be a Namasudra. I'm not an expert on the surnames, but Biswas and Namasudra can be interchangeably used.
It cannot be used interchangeably, Lordship.
Yes, can be.
But even in that case, assuming that to be correct also, Lordship, then even then there was no Biswas in the procedure while taking cognizance of that, Lordship. It was always against Mayamoti Namasudra.
This great teacher says this is a common Bengali family name which is used across various groups, including general forward castes, scheduled castes, including some Namasudra families, and Bengali Muslims or Christians.
And that being said, in the written statement in para number 3, Lordship, that I will leave up to your Lordship, but in para number 3, Lordship, the ematology of that Namasudra, Lordship, I'm not very aware of that, Lordship. But as per the written statement, Lordship, she is categorically stated that she is not a Namasudra, but she is a Biswas.
Well, there is no work we have business.
नामासूत्र कहने क्या है नामासूत्र है विश्वास इमाटोलॉजी में मारवा
So, Sama, go through this, what is trying to show from the LCR. The initial orders where the SP was directed to make that inquiry. Let's see that.
Monomoti Vistas, Mayamoti Vistas. Then Lordship, what document he has placed Lordship to link with Jivan Vistas Lordship? Nothing has been placed before the tribunal Lordship. Not a single document Lordship. Yes, Lordship. He projecting herself as a daughter of Dinesh Chandra Vistas. So, but there is nothing, no mention and no document has been placed. But she is the daughter of Dinesh Chandra Vistas. Otherwise, I think that actually is not helping, but proceeding also. Order to payment
24/4/16. Take number 3, sir.
Mr. P. Decker, and counsel for the petitioner, and so and so for the respondents. The matter has been heard or reserved. Just examine it.
Lordship, this is with CAV.
Had you not shown that inquiry order, we would have dismissed it right now.
Lordship,
We would have dismissed it right now. If there was no link, please write otherwise. There's no link. If that was then
Lordship, may give me a chance, Lordship.
we don't know how the table turns. I don't think we'll be able to take up any matter. There are two matters, production and.
I'll do it.
Production list item 1 for motion WP criminal 40/26.
Lordship. Here, your lordship, we have put to challenge your lordship the order of detention as well as the subsequent order received by which our representation has been rejected, your lordship. Detention order of us.
Page 65. Which page?
Page 65 is the detention order, your lordship.
65.
65. Passed by the state government, your lordship. Page 65. Rejection to the person. 120 is the order of rejection of my representative.
Page number?
120, last page of the 120.
120 is the detention order.
65 is the detention order.
85.
65.
65.
Five.
Okay. And the grounds?
Grounds of detention, your lordship will find at page 67.
And what is page 120?
120 is the order by which our representative has been rejected by the state government.
Okay, at this stage we'll issue a notice.
Not. Open it up, for the video. It's not going to be a affidavit home. Lordship, that representation is of the 75 Your Lordship. There are two representations. First representation has been '77 is the vernacular. Vernacular. No, not here. Sorry, Your Lordship. I should say Your Lordship. Originally, of course. Second representation, Your Lordship will find at page 96. Initially, Your Lordship, councils are not allowed to meet Your Lordship. Thereafter, we approach the Honorable Court, High Court. The direction was issued and then. Lordship. Lords, Lords.
EF dash 821-601/81 dated 30/7/2026. Comma the and the grounds of detention is at page 67,
Lordship, 67.
bearing number small e capital CF dash 821-601/84 dated 30/7/2026. And that first you say, detention order is also issued by the Commissioner Secretary to the Government of Assam, Home and Political Department, which is served on the petitioner on 30/7/2026. Then number two is grounds of detention bearing number small e capital CF dash 821-601/84 dated 30/7/2026. Issued by the same authority and duly served to the petitioner on 30/7/2026.
31/7.
31/7, okay, 31/7/2026. Comma, as well as the order number small e capital CF number 821601/132 dated 14/8/2026, passed by the Additional Chief Secretary to the Government of Assam, Home and Political Department, thereby rejecting the two representations submitted by the petitioner.
Only one, Your Lordship.
It's only
First
one.
one.
First
First
one.
one.
Okay. Representation dated 4/8/2026, submitted by the petitioner. Next to that. In view of the projection made in this petition, issue notice returnable on due date after 15 days. Returnable on so and so. Requisite extra copies of the writ petition, as well as one scanned copy of the writ petition be served to the learned CGC as well as to the learned government advocate in course of the day. So as to enable the respondents to file their affidavits. Next one. List on.
Deeply on.
But copies, please give
I-
that
I will.
e-copies and that.
That I will.
Okay. Because last time, so that the registration, look at the name of Sankari Chaudhary of DSGI by missing the matter text.
Production list item 2.
May it please your lordship. This I is filed for substituting the names of the legal heirs of respondent number 19, Mr. late Jogeshwar Saikia.
Your name,
G Das.
but this is G Das, and also for the applicants. Also heard Mr. P.K. Sharma, Government Counsel for the opposite parties. Next one. By filing this interlocutory application, the applicants are seeking their substitution as legal representatives of the respondent number 19, namely, Jogeshwar Saikia, Jogeswar Saikia. Is stated that the respondent number 19 had expired on, when did he die?
Lordship, in 2022. 16/8/2022.
Order 22,
Yes, Lordship.
Rule 4. Then the issue of abatement and the effect of consequences of abatement arise. We'll have to file applications for pondering the delay as well as for setting aside abatement. Had this order 22 not been used, once you've used it, you'll have to file an application, you'll have to adjourn it. Next paragraph. This application has the provision of order 22 rule 4, read with rule 11 of the CPC has been invoked, comma. The respondent 19 having expired on (16 8 2022). Could be hit by the abatement of by the principles of abatement. Next paragraph. Moreover, it is noticed that the proceedings of WBC 6498 of 2023 was disposed of by judgment and order dated 27/10/2022. That is before the respondent number 19 had expired. Comma. The applicants shall address the court as to whether person who has died before the judgment and order dated 27/10/20 was passed can be certificated in a manner in the present manner. As per a matter sent John this term, what is the date given? 9/26. You just find out whether it can be done.
Yes, Lordship.
Person who has died before the order, can he be substituted like that? We'll have to rise for the single bench. Other matters could be rolled over. The matters will be rolled over.